Welcome back, everybody. The next session in today's training program is Public Records in Oregon, what city officials need to know. I don't know that most people find public records super exciting, but it is definitely something that all officials in Oregon should be aware of. So let's chat about it. We're going to start by talking about the purpose of the Public Records Law. And the reason I like to start with understanding the purpose is because at some point you might become frustrated with all of the rules surrounding public records or the massive amount of records your city is required to keep. And I always think if we can understand the reason behind the law, we can perhaps at least better appreciate it, even if we still don't like it. So there's two reasons we have a public records law in Oregon. The first is for an informed citizenry. The reality is that we do actually all work for our community. We work for the citizens. And so the business that we do impacts them directly. And the citizens have a right to know what we're doing and why. If you think about it in reality, especially if you're a city councilor, you have an enormous amount of power and control over your citizens. I mean, you get to tell them how tall of a fence they can build. You get to tell them how many dogs they can own. You get to tell them how much they have to pay to get water. So you have an immense amount of control over their everyday life. And as a result, we have a public records law so that they get to understand the reasoning behind the decision you've made and all of the data that went into those decisions. The other reason we have a public records law is so that we can understand our history. For those of you that have been in office for a little bit, my guess is at some point you came across an ordinance or a policy that a prior council had done and you thought, what were they thinking? Why would they have chosen this course of action? And the reality is you may never agree with the decision, but because of the public records law, you have the ability to go back and look at the data that council had before them and the reasons they made the decisions they made. Again, you may still not have agreed with the decision, but at least you can understand the rationale behind why that decision was made. So, in public records law in Oregon, we actually have two types. There's the law as it applies to retention, and then there's the law as it applies to disclosure. And we're going to take them separately here. We're going to start with retention. I always like this photograph because it looks probably like what a lot of cities look like. To be honest, kind of looks like what the league looks like at times. But retention, what records do we have to retain as a city? So in order to answer what records you have to retain, the first question we actually have to ask ourselves is, what is a public record? So remember, I literally just said there's a retention portion and there's a disclosure portion. And us lawyers like to make things differently. So public record definition is different under retention than it is under disclosure. So we're going to give you both. So for retention purposes, a public record is any information that is prepared, owned, used, or retained by the city that relates to an activity, transaction, or function of the city and is necessary to satisfy the fiscal, legal, administrative, or historical policies, requirements, or needs of the city. So take 5 seconds and you tell me what document you create as a city that does not meet that definition. It's probably going to be pretty hard. Most things are probably public records. And if you're somebody who errs on the side of caution, I encourage you to just assume it probably is. What is not a public record? So what the statute does is what most people hate. We're going to tell you what a public record is, and then I'm going to give you a whole host of examples of things that it's not. So let's walk through some of those examples. So extra copies of a document. If you've got extra copies, you don't have to keep them. You can throw those copies away. One little tip I like to get. My guess is almost all of you get what's called a council packet before your meeting. Some of you probably still get a hard copy of it, and you probably take notes on it, right? So my question to you is, if you pitch your packet, did you pitch a copy of the actual packet? Or did you pitch a document that was somehow new because you've modified it with your own writing? If you've modified it, it's probably not the same document your city recorder is keeping pursuant to the public records law. So you want to think about that before you make notes on things. Are you creating a new public record? And if so, what are you doing with it? Now, I myself, what I do is I don't take notes on packets or legal pads. I take all of my notes in one notebook. And the reason that is so I know all of my notes are in one place. So when we get to the disclosure part later, at some point if somebody came and said, hey, Patty, we have a public records request, and I think your notes might be part of that, I really know that if I had it, it's only going to be in one place. It's going to be in my notebook. And when I worked for an actual city, instead of looking for an organization like the League, I actually had different notebooks for different things. So, for example, I had a notebook that was only related to my city council business. But I also worked with my planning commission. So I had a notebook just for my planning commission. We had a local pension board that I staffed as well. So I had a notebook for my pension board. And the reason that was so everything was contained, and everything I did for those was all in one place. But going back, what else is not a public record? So in addition to extra copies, stacks of publications. So if you get newspapers or magazines, those aren't public records, you can go ahead and recycle those. Messages on voicemail or other types of telephonic message storage. This is an important one. So what is clear is if you keep a voicemail, when we get to the disclosure section, you're going to learn that you have to disclose that if you get a public records request. But you're not required under the retention standard to keep it. So if you get a voicemail, you can delete it as soon as you listen to it. But if you chose to save it and a public records request comes in, you're going to have to disclose that voicemail if it's responsive to the request. And then, as always, the thing that we hate to do anymore, when you speak to people directly, that's not a public record. In Oregon, every single city has an obligation to retain its records or an accurate copy thereof. And we have to do it in accordance with the retention schedule that is set by the state archivist. So if you are interested in what that looks like, it's a pretty lengthy retention schedule, but it's also pretty helpful. But some records we only have to keep for a year, some records 5 years, some records 75 years, and some records, like your charters and your ordinances, you have to keep perpetually. But every city is required to retain its records in accordance with that schedule. It is technically a crime to destroy, mutilate, conceal, remove, make a false entry in, or falsely alter any public record. Now, a lot of times when I do this training live, what I'll see is a bunch of panicked faces looking back at me because they're thinking to themselves, uh-oh, I throw away Post-its with writing on them all the time. Or I have been writing in my council packets for years and I have just been shredding them and now I'm panicking because am I a criminal? A lawyer answer, sure, technically, but in reality, what I always like to tell people is we can't undo what we've already done. We can't unring the proverbial bell. What we can do is take steps to learn and move forward and do better going forward into the future. So just always remember before you pitch something, destroy it, or try and change it, should you be doing that if it's a public record, or are you in fact tampering with or destroying them in violation of the law? Every city, in addition to being required to maintain their records in accordance with the Secretary of State Archivist schedule, is also required to identify a records officer or a records custodian, if you will. In my experience, if there's any city recorders on this training, my apologies, it's typically the recorder. They are usually the person who is going to be in charge of the entire city's record management system. They're going to be the persons who make sure they're organized properly. They're going to be the persons who handles any requests for a disclosure of a public records. But you as a city have to specifically identify who that records custodian is. And what I always tell people here when we talk about the records custodian, so remember the notebook that I have, all of my notebooks. So if that's something that you do as a counselor or something you decide to do, let's say as a mayor, like I'm gonna take Patty's advice, I'm just gonna use a notebook for all my council meetings. You need to let your city recorder know. Because if your recorder ever gets a request for public records, The recorder needs to know that, hey, the mayor has a notebook over there, and I need to make sure I have access to that notebook to see if there's any records in that notebook that are responsive to this request. So the first key with this slide is you got to identify who your records custodian is, and you need to communicate with your custodian about how the city and you are retaining your records. The state archivist is really there to help. So I actually serve as the league's records custodian a lot of times, and what I can tell you is that it's not always clear to me what retention schedule I have to follow. Is this document a 5-year document or is it a 10-year document? Can I destroy this document now or can I not? And you can call the state archivist, and they are incredibly, incredibly, incredibly helpful. And they will give you guidance and assistance so you know what you actually have to keep and for how long you have to keep it. So then we move into the disclosure part. In some ways, this is actually the harder part. I know retention seems hard because where are we going to put all this stuff? But the disclosure part can be a little bit more complicated and, quite frankly, sometimes embarrassing. So if you remember from earlier, I said we were going to have a different definition for disclosure. It seems a little bit the same, but there are some subtle differences. So for disclosure, the records that the public is entitled to see, a definition for public record is any writing that contains information relating to the conduct of the city's business, which is prepared, owned, used, or retained by the city, regardless of the writing's physical form or characteristics. So if you couldn't tell, I tried to highlight that last bullet point with the tone of my voice. And the reason is because the writing's physical form or characteristic means that emails are public records, text messages are public records, and in certain instances, social media accounts can be public records. Audio recordings are public records. It's not just a piece of paper anymore. It can literally be anything that we create or produce information on. And that's key because it could impact what you do. So again, we know what a public record is for disclosure. Now we'll talk about what it's not. A public record does not include any writing that does not relate to the conduct of the city's business and that is contained on a privately owned computer. So this is always interesting to me. So a lot of times you will sometimes see city officials who have two phones. They have their personal phone and then they have the city phone. And that's probably a recommended best practice. And the reason I say that is I'll use myself as an example. So let's say I use my personal cell phone for league business. So the league is a public body, in case you didn't know that, so we're subject to the public records law as well. So let's say I send text messages to city councilors, to my boss, to colleagues, and I'm using my personal phone to do it. And I also text with my daughter, who's in her 20s, and let's say that I'm not having a great text exchange with my daughter because she couldn't pay rent and I now need to pay her rent. Although on Instagram she was having a lovely time, of course, pre-pandemic, at a bar with some of her friends. And I think to myself, I know where your rent money went. And so our text exchange is not one that I would probably want anybody outside of my husband to see. And so we get a request at the league. We want any and all text messages that Patty Mulvihill has sent related to this board item between May 1st and June 15th. Okay, so my text message to my daughter is clearly not related to city's business and it's on my cell phone, so it's not disclosable, right? Well, here's the tricky part. Someone has to go through my phone and your phone or your private email to identify what is or is not related to city's business. So when you mix your city business with your private business, it is true on your private phone that those private messages will probably not be disclosed. But it's also true that your records custodian or your city attorney may have to cull through and read some of those private messages to determine whether or not they are in fact city business. And that's sometimes, I think, a delicate situation. The other thing is there's been evidence or instances, in Oregon where people have done work on their private computer, done city work on their private computer or their private phones, and they end up in litigation over something. And under litigation rules, so under discovery rules, those private computers and private cell phones have been essentially confiscated temporarily for discovery purposes. So if you can, do your city business on separate city devices or city accounts, That's the best practice. If your city doesn't have a city email account, which is sometimes what I get a question about from counselors, is I always encourage you to create your own separate city email. So let's say, for example, your city doesn't have an email account for you. You could say mayorofgreenhorn@gmail.com, and just know that you're only going to do your city business for the city of Greenhorn through that email address. And a common question I sometimes get from people is, yeah, but it's a small community, Patty. People know my email address, so they just email me on my personal email about city business. Perfectly common. You're probably never going to be able to stop that. What I always do if that happens to me is I take the email that came to my private email account, I forward it to my league account, and then I respond from my league account. And I say, hey, Susie, I got your email. I know you probably sent it to me at my Gmail account because we're friends and that's how you know me. But when you want to talk about this business, I really need you to use this official address, because then it's still now officially on my city account and I can delete it from my private account. That way I never have to worry about having to turn over any of my private devices. So, right to inspect. Every person has a right to inspect any public record of the city, unless it's a record that can be specifically exempted. What's important here is any person. It's not just citizens of your community. It's not just residents of Oregon. Any person, anywhere in the entire world can file a request for public records, and assuming they are records that have to be disclosed, your city is going to have to disclose them. There are certain types of records that are exempt. There's probably between 40 to 50. We're not going to go through them all here. The people who are most intimately familiar with whether or not records are exempt are probably your city recorder, your city manager, and your city attorney. Generally, there's two types of exemptions. There's the conditionally exempt exemptions, and then there's a particularized finding. What I usually try and tell people is, if you're a counselor or a city department head or staff person or mayor and you are not the records custodian or the city attorney, it's really not for you to worry about whether or not a record is going to be disclosable or not. From my perspective, it's always better to just assume whatever record you're creating could be subject to disclosure. And one of the best examples I like to give is, in one of the cities I worked for in the Midwest, we had a massive city park that we owned, and it was pretty rural in the area, so we had a heavy deer population. And the deers there was too many deer, so they were destroying vegetation and damaging the park, and we had decided as a city that we were going to do a cull. We were going to cull the deer population. It did not go over well with a significant segment of our citizenry. In fact, PETA got involved, if I remember correctly. And we ended up having a series of multiple meetings. I mean, lots and lots of meetings, very long meetings, and these were all essentially public meetings or public hearings. And one of our department heads was taking notes at all of the meetings. And some of these comments from the public were a little outrageous, if you will. For example, one person in particular who was opposed to culling the deer suggested as an alternative that the city identify a way to create a condom and then identify a way to put that condom on the deers, because that would stop them from reproducing and ultimately save the park. I don't know if you're laughing at home watching this, but as staff, we had some thoughts about that suggestion, and you can imagine what those thoughts look like. And unfortunately, one of my department heads wrote some of those thoughts down, and they weren't kind thoughts. You know, thoughts like, this person's crazy. I think this person's on meth. I mean, they were not kind thoughts. Thoughts that I think probably most people would think, but he put them in writing. Fast forward, the hearings are all over. We're going to call the deers. And we get a massive public records request. And they want any and all records related to all this stuff. So we go through our process. You know, we're putting together all these records. And the department head comes into my office, and he's got his notebook, because he uses the notebook philosophy the same way I do. And he's like clutched against his chest. And I said, oh, hey, is that the notebook? Can I have it? And he goes, no, like this. I said, no, seriously, give me the notebook. And he said, I don't want to give it to you. And I said, well, why not? So then he starts showing me a lot of his notes. And he's like, but we don't have to disclose this, do we? And I said, yeah, we got to disclose this. That's not a reason to keep it exempt. And, a couple of weeks later, the front page of the paper is department head thinks citizens smoke meth. So I tell that story to caution you that whatever you write, whether it's on your notebooks, whether it's on your council packets, whether it's an email or a text message exchange, or you put something on the city's Facebook comment page, just think about whether or not you would feel comfortable if those words ended up on the front page of the paper, or they were words you had to defend in court one day. That's what I always talk about when I talk about whether or not records can or cannot be disclosed to the public. What's important to note under the public records law in Oregon is that all of these records that you can refuse to disclose, so if I go back, so if you had the ability to withhold some of these documents, so one of the exemption applies for a city record and the city decides we're not going to respond to it. So a common one, if you have a police department, for example, you typically do not have to release criminal investigative reports. Those are traditionally exempt. Okay, so let's decide in this instance that there comes a case where you want to disclose that information. As a city official, you have the right to say, I am willing to disclose this record. And you can choose who you're disclosing it to. So you can say, I have the right to not disclose this record, but I'm going to voluntarily give it to person A and only person A. That is a right that you retain under the law. Here's the key. There are certain deadlines for responding to records requests. Once a request for public records come in, the city has exactly 5 days to acknowledge it has received that request. And there's specific things within that acknowledgement that have to occur. And then 10 days from that 5-day deadline to acknowledge it, the city either has to fulfill the request or they have to provide a written estimate of how long it will take to fulfill the request. These deadlines are super important because there's penalties that your city can face if you fail to meet the deadlines. So the best way to ensure that these deadlines are met is for your records retention policy to say the only person who can take a records request is your records custodian. In other words, probably your city recorder. So if you're the mayor and you are at a Chamber of Commerce meeting at 2 o'clock in the afternoon, and you've got a council meeting later that night, and as you're walking out, one of your constituents comes up to you and says, hey, Mayor, I got a request for public records. And you think to yourself, I'm going to take it, and I'll just give it to the recorder when I see him tonight because that will just be more helpful. And you put it in your bag, and you know your bag's going with you to council meeting. And then you get distracted with the rest of your afternoon. It's a little chaotic at home while you're having dinner before you go to your council meeting, and you just forget. And you're cleaning out your bag the next Monday before you go to your council meeting, and you pull out that records request. Well, the 5 days has expired, and now the city is in violation of the records law. So because you have such tight deadlines with such specific requirements on how to be handled, it's really important that the only person who accepts requests for public records is your identified records custodian. If the city or an appointed city official denies a request for public records, the person who wants the records can file an appeal to the county's district attorney. Now let's go back to my mayor example who's trying to be super responsive to his constituents and takes the records request at the chamber meeting. This is another reason why you don't want to do that. Because if the mayor had denied a request for public records, and by not acknowledging it in 5 days, that counts as a denial, then the appeal can be filed in Marion County or the circuit court where the elected official is located. So think about it. If the city or the recorder denied the request, it goes to your county district attorney. If an elected official, your mayor or your council, denies or fails to respond to that request, then the appeal automatically goes to court. And what's worse, it could go to Marion County Circuit Court. So if you live in Ontario, Klamath Falls, Astoria, Brookings, do you want to be litigating a case in Marion County? And for those of you that don't know, Marion County is the city of Salem. My guess is no. So all the more reason to make sure that your requests for public records always go through your records custodian. There's a whole bunch of resources out there if you've got questions about public records. The best one, in my opinion, is the Oregon Attorney General's Manual on Public Records. The Oregon Secretary of State's retention schedule is super good. LOC's got a couple different policy manuals and FAQs that you can use if you've got questions. And the best way, quite frankly, is if you've got questions and you don't know where to start, you can just call us or send us an email at the league, and we'll be happy to point you in the right direction or give you the answer that you need. So, we're ready for live Q&A. I'll chat with you shortly.
Welcome back, everybody, to your second live Q&A, this one devoted to public records. So, Lisa, what's the first question?
Okay, first question. When is or isn't social media part of the public record?
This is an excellent question. It's one Jamie and I get on the regular basis, and I will probably give you one of the most unsatisfactory answers possible. The answer is, it depends. And it depends, quite frankly, because the law has not quite caught up with social media, particularly in the government context. And so what you have to be mindful is that there are legitimately times where social media can be considered not only a public record, but in certain instances, it might even constitute a public meeting. And so what I can tell you for sure is if it is a city website, so if your city has its own Facebook page, its own Instagram page, its own LinkedIn page, if it has its own page, that is most assuredly going to be some form of a public record. And so you want to be mindful of the comment feature. So a lot of times people want to start deleting comments they don't like. You've got to be really careful of that when it's an official government page, because that could be seen as some type of censorship or destroying some type of public record if you're kind of getting rid of it. If it's your page, so let's say I became as brave as most of you watching and decided to run for office. It will never happen, but we'll pretend. And I was the mayor of my city, and I created the mayor's Facebook page. That's probably going to get pretty close to being a public record. And then the other one is it's my private account as a private citizen, but then I start using that account to talk about city business. And there's been a bunch of cases recently over the last 4 to 5 years, where courts are starting to say, even if it's your private account, if you are essentially using your private account to do city business, then it's probably city business. And there are some courts that are starting to say those private pages are becoming essentially public domains, so they are becoming public records, and or in some cases public meetings, depending on if you get a quorum of counselors starting to debate each other on comment features. So what I generally tell people is when the city's got its own page, that should be managed and administered by, whatever policy you have in place, so a limited number of people, and those people should be having conversations with their city attorney about what they can and cannot post and can and cannot delete and how they are maintaining that record. If it's your own, Patty Mulvihill's mayor page for the city, I should also still be having a conversation with my council. Are there expectations about what I should or should not be posting on there? Do we have council rules of procedure that govern? So for example, there's a lot of cities that say, even if the vote was 5-2 and I was on the 2 side, we agree that the city reached a decision and we're not going to badmouth the city's decision. We're going to speak on behalf of the city even if we were on the losing side. So talk with your council, talk with your city attorney, what restrictions do I have here? And then if it's your private page that you're doing yourself, but you find yourself engaging in what is clearly becoming city discussions or business that impacts the city, you want to take a pause and ask yourself and do a risk-reward weighing. Do I want to risk creating a public record on my private Facebook page? In a lot of ways, it can be very similar to doing work on your private laptop or on your private cell phone, so you need to be mindful. I would say that I think the pendulum is probably going to swing more on the conservative side on this, and that if you're doing city business on your private Facebook page, it's probably going to be deemed public business at some point in the future. Not quite there fully yet with the courts, but I do think when you read the public records law, particularly its intent and its purpose, that's kind of the slant it's taking. Do you agree, Jamie?
I do, and I think when you're receiving those comments on your personal Facebook page, if you have a counselor Facebook page, I would just have a kind of generic response that says, if you have comments or questions about city business or my capacity as a counselor, please go to my counselor page, or please email me at your counselor email address. Because, it's hard. People know you in your community as your personal, private life. And so a lot of times you probably will receive questions about city work, even if you don't have a public Facebook page. So just direct them, keep it separate. And it's okay to have that generic response and just say, hey, if you want to talk about city business, here's how to reach me.
Great point. Lisa, next question.
Okay, the next one is a two-part question. So from an archiving and retention standpoint, does your notebook need to be scanned as part of the record or just available? If just available, if you were to leave city council, would you need to provide it to the city upon your departure?
Those are great questions. So if it depends, it's going to depend on your city's policy, and I hate to keep going back to that. You'll probably hear me that a lot. What I have done in my experience when I've worked with cities is we've just kept them. So, like, for example, at the League right now, I'm up to my 7th notebook, and they are all just stored in one place by date range, so that if anybody ever asked me where they were, they could go there. When I leave, I will leave my notebooks with me. So I know of a counselor who I think actually was on the coast for a while and wanted to keep their notes in step with them. The counselor liked to refer to them even several years later, the historical context. And when the counselor was no longer on the council, it's my understanding he dropped off several bankers' boxes worth of notes and records to the city recorder and said, here you go, here's all my records, they're now yours. So in my experience, the best conservative practice is to make sure that you keep the records, and when you leave, you give those records to the recorder. And whether your city decides they want a paper copy or they want to scan them when you're done, that's really up to each individual city to decide.
Yeah, the most important, I think, piece of advice is just to have the conversation with your city recorder or whoever is in charge of handling your records, so that everybody knows how the city would prefer to store those records, and then there's no surprises later on. So you're not stuck scanning hundreds and hundreds of pages when from the start you could have had maybe a more preferable method. Just have the conversation.
Great.
Okay, the next question. My understanding is that cell phone carriers don't actually maintain text perpetually and have a 30-day purge rule. What should cities do if that is meant to be a part of the record? And does it also apply to Facebook Messenger and or other messaging platforms?
Well, that's a great question. So I don't know technology in terms of their storage stuff as well. I'm going to let Jamie, because I think she's been stuck in this before with the state.
So it varies. So Facebook is probably going to have a different internal disposal, I guess for lack of a better word, system than your cell phone carrier. And I think even amongst Verizon versus AT&T, they're probably going to have different methods. So it's actually, the onus is really on the city and then the public officials on retaining those records. So if you don't know the storage policy of your cell phone carrier or Facebook or Twitter or whoever, make sure you are saving copies of your communications. So whether that's, if it's a text message, whether you are forwarding those to a city server, Facebook, if you are saving messages or saving screenshots, I don't know, cities do it all different ways. I wouldn't rely on Verizon retaining the records on my behalf, because ultimately, if say you were a respondent to a public records request and the record was destroyed, the court doesn't really care about Verizon. They're going to go after you. So me personally, if I'm the one responsible, then I need to take the steps to make sure I'm following the law.
And so I think I've said before, maybe I said it, I don't know, it's a little weird pre-recording a training session and not doing it live. So what I've seen a lot of government officials now is they will issue their employees, and in some instances elected officials, basically a city cell phone, and then you have your own private cell phone. We don't have that at the League, we just have one. And so what I do is any work-related text that I have, I've never deleted. It just stayed there in perpetuity, so that in the event that somebody would ever ask for it, I would have it. And I just don't delete them, they're there. And when I upgrade or if I transferred, I would print those out and store them. But you need to be mindful of them. I think if I can use this opportunity as a tip, it's that technology has made our lives super easy in a lot of ways. And I'm not trying to encourage anybody to get around the public records law. It's there for a reason, and it's a valid reason. But sometimes I think we get in the habit of sending texts or messages or comments when a phone call would suffice. And by that I mean is that instead of having a 5-minute text exchange and then worrying about the record that you've created, how it's going to be retained and what's going to happen, it might be a lot easier to actually just talk to the person on the telephone, because there's no record retention to worry about when you're having a verbal conversation with somebody. Do you have other questions, Lisa?
One more. Given digitizing is the path forward, are there vendors that specialize in transitioning paper-based archives to digital? Do you guys know of any? Some people did reply in the comments with a few suggestions, but.
Yeah, so there are. I don't know any off the top of my head. What I would suggest that you do is, so the Oregon Municipal Recorders Association, they are going to be the best people to ask, because the recorders are going to be the people who are primarily responsible for digitizing all those records. So my guess is if you ask your recorder, and the recorder asks their fellow recorders on their listserv, is you would probably very quickly get a list of companies that can come in and do that digitization for you. Any other questions that we might have? I'm going to let Lisa scroll through and see if we've got anybody coming in. While she does that, after this segment of Q&A, we have built in a break so that you guys can get up, stretch your legs, grab some coffee, take a bio break, whatever you need. And when we resume, it will be at 11:15 with ethics. Jamie Hafner is going to give you a presentation on ethics, and then there will, of course, be Q&A after that. So I will do one last call. Lisa, do we have any more questions in the queue?
I do not see any more questions.
Okay, so we're going to take a break. This might be a good opportunity if you're still listening. If you have questions as the day goes on about one of the topics we've already covered, or if in 2 or 3 weeks you've got a question, please feel free to email me or Jamie at any time. In fact, a lot of times we will encourage people to email us both simultaneously. That way, if somebody's on vacation or Jamie's super busy that day, I know I can jump in and answer it. Particularly since we're telecommuting, email's the best way. So don't feel pressure today. If you want to take some time, you can ask us questions at any time.
The first one is just a quick follow-up from the last segment, and it is, are not all city councils nonpartisan in Oregon?
I don't know of any that are partisan, so I have not looked at all 241 charters, but I think almost all of them are nonpartisan.
I'm not aware of one that is. It doesn't mean that there isn't, but my understanding is that the most partisan you're going to get is just when you have councilors by like regions or districts, but they're not political affiliations.
Okay. The next question is a two-part question. How can it ever be determined that a voicemail was retained and therefore should be disclosed upon request? That is a request for a voicemail even obtained through appeal to a district attorney?
So some of it is going to just be the honest, the honest factory. So, I mean, the question is I don't know. It's like, if the trees fall in the woods, does it make a sound? So the reality is if you save your voicemails and a public records request comes in and one of those saved voicemails is responsive to that request, you have a legal obligation to turn that voicemail over. You have no legal obligation to save your voicemails, but if you are somebody who does and a request comes in for that voicemail, then you would have to disclose it. So it's kind of the honor system, to be perfectly honest. So if you're somebody who saves voicemails and a public records request comes in, then you're going to have to see if any of those saved voicemails are responsive to that request. But for retention purposes, they are something that can be destroyed as soon as you listen to them. You're not required to retain them.
Okay, next question. Does every city give a laptop and/or cell phone?
No, that would be surprising to me. That's a decision for each city to make. I will tell you that particularly in the last 9 months with the pandemic, I think a lot of cities have gone to more technology for their counselors, but it's not common. In fact, I'm pretty sure about a year or two ago, we did a survey in terms of kind of governance, like compensation packages for elected officials, and I would say it's the minority of cities that provide laptops or cell phones or even financial reimbursements for them to use their own in cities. Most cities, it's still not something that they provide. If it's something that you want to consider, that would be a discussion for your council probably to consider as part of your budget discussion to start allocating resources if you think that's appropriate.
Okay. next question. During this time of COVID, I am working a lot from home. Would using a flash drive for city business protect my personal computer from being confiscated?
Possibly, yes. So it's only going to be confiscated per se if you're in litigation, not necessarily for a public records request. So Jamie can tell an interesting story about the state with confiscation stuff, right? Didn't a bunch of attorneys lose their stuff?
No, that wasn't something I had experience with, but my experience oftentimes is we get a request that says we want to see all email communications about this one topic between, this time frame. So the person in charge of going through those records asks everybody to send them those emails. And a lot of times we would get some non-related emails, which may or may not contain some embarrassing personal information, like they were emailing their significant other or just a friend and just giving details about things that are completely unrelated to life in the public sector. And so you want to ask yourself, is that something you want another staff member to be looking at? Probably not. So the more separation, the better. So if, because you're working from home, having separating your city work with a flash drive, and then later on you can say, I absolutely don't store any information on my personal computer. It's all right here in this flash drive, then the better, because then there wouldn't be a reason to go through your personal technology.
And the other thing I would suggest if you're doing the flash drive route, which I think is a great idea given your situation, is when you're finished using the flash drive or it's all stored up, I would have a conversation with your city recorder about them maintaining it instead of you. So it's almost treated as city property as opposed to your personal property. So that kind of just makes it more clear that this is not something that I own and something that I do. This is kind of my city work, and so I'm giving it back to the city for record retention purposes when you're done with it.
Okay. Next question. Can you talk a little more about social media? For example, if a counselor has a city council specific Facebook page and receives feedback there, how do we handle this?
So social media is always one of the hardest questions we get, and it's probably one of the most unsatisfactory answers we give because it's an emerging area of the law. And by that I mean what we have found as lawyers is that the law never ever keeps pace with technology. And even though social media has been around for a really long time, the law, and at least as it relates to public records and public meeting law, is still not quite up to speed with it. So what I can tell you is that if it's an official city Facebook page or Instagram account, LinkedIn account, whatever, those are most assuredly going to be public records, that those posts and stuff are going to be there. If it's your, like you described, I'm, let's say, the mayor of Salem. Let's say I've replaced Mayor Bennett, which would never happen, but we'll pretend because that's the city I live in. So I'm the mayor of Salem, and I have my own Mayor of Salem Facebook page, and I'm doing city business on it. I would tell you to err on the side of caution that that probably is a public record document. The comments and features on those are probably public records. The tricky part really is when it's your personal page and you start to veer into doing city business. So several courts have recently been issuing rulings that suggest that if it's your own personal page, but you're actively doing government work or you're talking about government priorities or government issues, all of those comments that are happening on those feeds and stuff, those can still be subject to public records even though it's your private account because you're actually really doing public work on that private account. So you have to be super careful with that. The other thing, it's not necessarily related to public records, but there have been some also cases developing that show that, let's say for example, you had your Mayor of Salem Facebook page and other counselors started commenting on things and you all start using, the chats and you're basically commenting back and forth on a post together. That might lead to a public meeting as well because you're doing it there and you haven't publicly noticed it. So social media is really hard. What we typically recommend at the league is that you sit down and you see, does your city already have a social media policy in place? And those are typically established and approved by the council with a lot of input from staff and city attorneys. If they do have a policy, then you're going to want to make sure that you follow that specific policy. If your city doesn't have a policy yet, and don't feel bad if you don't, these really are emerging. I will be honest, I got an email request just yesterday from a relatively large city in the metro region who's just working to establish a social media policy for their community or for their council. Have the conversation, sit down, with your city manager and say, look, I really want to make sure we have this policy in place. Can we start developing one? What do we need to do? Can we loop in the city attorney? Because there are just enough gray areas right now that that you want to make sure you know where those gray areas are, and you decide as a council how deep into the gray you want to go, so that if somebody would ever file a complaint or an allegation that something is a public record or that was a public meeting, you've kind of already pre-vetted your comfort level and you know what defenses you have if you get those allegations. Jamie, you have anything you'd add?
Nope, all great advice.
Okay, so this is kind of a follow-up with that. If you have a personal account but with a page created for your city council position, does that separate enough from private and public pages?
I think any separation is good. I don't know if I've said this yet today. Jamie and I, and Colton, if you talk with him, he's the other attorney in our organization, are always going to give you the most conservative advice possible because we represent all cities, and so we want to give you the most conservative approach. I think any separation is good. If it were me, I would say the most separation is the best. So if you can have a completely separate account. So it's just literally Patty Mobile has her own private account and I do all my private stuff up there. And then there's a completely separate account, separate email address, separate login. Everything is completely separate and never the two should meet. I would say that would be the safest course of action. But if you have a separate page, that's at least some separation and you've got an argument that you've kept them separated.
Okay. Next question. How can a social media policy be anything other than a policy that complies with free speech rights? That is, best practices or recommendations only?
So I don't know if I'm assuming, I'm going to go out on a limb. So if I'm wrong, please type furiously into the comment feature. So what we see with social media policies is a lot of times is counselors will say, look, you can't tell me what I'm going to say. I'm not comfortable with it. And that's a position to have. What a lot of councils do though is they establish agreed upon policies, norms, and rules, and if certain counselors choose to ignore those, they can be at times what we call censured, which is almost a public shaming, so to speak, that we have these rules and these expectations, you chose not to follow them, and that created a bad image or a bad reflection on our organization, and so we are going to issue you this public reprimand, essentially. A lot of social media policies, there's a lot of them out there. Some of them are really vague. I mean, some cities go so far as to say you can only take a position, the city's only speaking through its official page, right? So you can't speak on behalf of the city unless you're speaking through the city's page. Others will have, okay, you have your individual account as your mayor, as your counselor. You know, police departments have their own pages, fire departments have their own pages, animal shelters have their own pages, and they'll have specific rules, you know, like you can't say that, you know, like the city's policy is X when it's actually Y. So if you voted on something and it was a 7-2 vote, you can't say that the city's position is, you know, on the losing side when it was actually the majority side. And then some won't have any. They just ask respectfully for people, you know, to not denigrate the city, to be mindful and constantly tell people you're not speaking on behalf of the city. So it kind of varies across the spectrum. You do have to be worried about First Amendment issues, and then the same provision in the Oregon Constitution, it's not called the First Amendment, but for simplicity, we'll say it that way. You have to worry about it, which is why we always suggest at the league when you craft a social media policy that you loop in your city attorney to make sure that those protections are there and that they're provided accordingly. Any other questions?
I am not seeing any other questions yet. Oh wait, here we go. If we keep our official correspondence on a separate email account, what happens if we comment to a friend or a spouse about the situation on your private email? Is that subject to being requested?
Possibly. So and it's going to be hard, particularly in my experience, small cities, and I say small cities can even be like 30 or 40,000 because suddenly everybody knows everybody and you can't go into the grocery store without running into somebody. So at some point, inadvertent mistakes will happen in that you're going to respond from your private email account because you know this person or somebody's going to email you to it. You're not going to be perfect. Don't expect perfection. What my best tip is when that happens and you realize it happened is forward that email to your city account so that it's all stored in there so that you know for a fact, and you could swear under oath if anybody ever asked you, that anytime I have done city business, it's either been from this account or I have immediately forwarded to that account so nobody has to look at my private account. Is that 100% guarantee? No, but it's probably, it's going to give you a lot of protection, and your city attorney, if they're defending you, is going to have a lot of arguments as to why that account should not be accessed because you've got it there. But But I should say this for all of the segments we're talking about today, give yourself a little grace, give yourself a little patience. You're gonna make mistakes. Some of you may have been in office already and you have made mistakes. I've made mistakes, Jamie's made mistakes. We will continue to make mistakes. Just take what you can from this educational experience and those you'll have in the future and try to do better, and just try to consistently improve upon any process that you're doing. But in that case, just forward it to your city account so that you know that you have a true and accurate copy of it in your city account. That's what I would do if I made that type of mistake myself. Any other questions?
I don't see any yet. I will just say, oh, we do have a follow-up before I say that. I assume the answer is no, but can things posted to personal social media account prior to being elected be called up?
No, because you're not subject to the public records or the public meetings law until you're actually in office. So they can't, say, be subject to a public records disclosure or, a public meetings potential violation. I think Jamie talked about this yesterday with some of our people. Still be mindful, though, that what you say in public as a public official, both before you take office, when you take office, and after you take office, will be held against you in a different way. So the public is always watching. They're watching you now that they know that you are a councilor or mayoral elect. So while it may not be subject to a public records request or disclosure, it could still be something you have to answer to if somebody's tracking what you're saying and they don't like it.
Yeah, and I'll add to that. We have the state laws, so the state public meetings law, the state public records law, state ethics laws, and those really should be seen as the bare minimum. So that's what you're required to follow. But then there's also the public's perception, which is maybe as a councilor-elect, you were really active on the community Facebook page, and technically you're not subject to the public meetings law or the public records law at that time. But does every community member know that? And can that create additional headaches for you down the line to have to respond to those community members that say, hey, you said this, or you held an inadvertent meeting? It just creates more work for yourself. So always just know, yes, following the state law is absolutely important, but also know that the public is going to hold you to a higher standard, and that while you didn't break any laws, it could just create a lot of excessive work.
That's a good point, Jamie. Do we have any more questions, Lisa?
I don't see any yet. I was just going to say, if for some reason you want to ask a question, but you didn't want everyone to see the question, you're welcome to send it just to me. I'm Lisa Trevino at LOC staff, so if you do have a question, you're welcome to send it just to me and I will read it. And we have about 10 more minutes if anyone has any additional questions.
So kind of a little tip, and I can't remember, I'm sorry if I said this in the video, but one thing Jamie and I always like to really tell people, if you're new, and most of you probably are new to office, one of the best things to do is sit down with your city manager and city recorder when you take office and just kind of ask, what is your city's expectation when it comes to public records? What's their process for keeping them? What's their process for destroying them? What do they need to know? What do they want you to know in terms of how to fit into the existing process, and how can they work with you in your style of note-taking or responding to citizens? Because it's like everything else in life. So if you remember from the video, we showed you that retention slide where there was filing cabinets that kind of overflowed. And the reason it's interesting is that happened because cities had been operating for years, like decades and decades, hundreds of years before public records laws come in. And so then it's like, what do we do with the backlog? You're going to find the same experience as a new council person. If you wait to have those discussions with your city manager and city recorder until June or July, you've already got 6 or 7 months worth of records that you now have to go back and figure out what you're supposed to do with. So if you can kind of get in front of the proverbial game, in front of the ball, and start those conversations early, I promise it will be a lot easier instead of trying to go back and undo what you've already done. So if you can think about that as something to kind of tickle, reminder, like, hey, sometime in January, I should probably make sure I have a conversation with my city manager and city recorder about what we do with records, just so you're not having to undo something you've already done.
During the pandemic, many cities are holding meetings over Zoom and are being streamed over Facebook. Some cities allow commenting to occur on the city Facebook's video recordings as well as regular Facebook posts, while others do not. Could you please talk about whether a city's Facebook page and the comments on the page are public record and how to deal with this issue? I'm under the impression that it is tricky to archive comments when there is the potential for commenters to delete their comments.
That is a great question. My guess is when we get into the public meetings question, we'll get more social media questions as well. So social media is tricky, and the reason I say that is the law has not quite caught up with technology, which I know seems funny because I think probably Facebook has been around now for a really long time, but we're not quite there. Well, our general rule of thumb is if it's an official city page and it's an official like city account, you should assume that those are public records and figure out a way to kind of archive them. There's no requirements that cities take comments or not take comments. When you talk with attorneys who kind of specialize in maybe First Amendment law, they would tell you that if you are a city that allows comments on your Facebook page, that you be very careful and mindful of deleting comments that you don't like, because that could be seen as some type of content regulation, which is prohibited. But generally speaking, what we tell people is that if you've got an official resource and you've got comments on there, you should assume that you probably have some obligation to keep those. My understanding, I'm not a tech person, is that Zoom's a little bit easier, that you can actually print those comments out. We use Zoom meetings in the pandemic for our board meetings, and we have had comments used in there, and we just attach them to our minutes as an exhibit so that they're in there for their record in perpetuity. I don't know, what do you guys do in Woodburn, Scott?
You know, we have a pretty active social media program in Woodburn, and we do have rules of comment that have been adopted. And we do archive those. If you comment on a city's social media page, that becomes an archived comment. Even the ones that may violate our comment policy are still saved.
That's great. So just err on the side of caution. If you don't know, so if you're a new elected official or you've been around and you're not sure what your city policy is, my recommendation is always to, kind of write that in your book of questions for your city manager and find out if there's a policy and you're just not aware of it. And if you don't have a policy, maybe sit down with the city manager as your counsel and discuss the pros and cons of creating a policy. Do you have
That's good.
any more questions, Julie? Sorry.
Yes, someone said, my notes on my council packets so far have been questions I want to ask at the council meetings. Do I need to save those?
That's a great question, and one that I get that people get super concerned about, because it's super easy for people to use their packets and put questions on. Technically speaking, what I find when I talk to most recorders is they keep a copy of the packet they give you for their records. So when you're writing your notes, even if they're questions, you are technically creating a new public record that the recorder probably doesn't have themselves. So I've seen a couple ways that cities have dealt with this. Sometimes recorders just collect everybody's packets and then they rip off the pages that have notes and add them so that it's there. Sometimes counselors like to keep their packets and then they just turn them into their recorder at the end of the year or when they leave. And then others do what I do, which I think I talked about in the video, is they just have a notebook, and that's kind of where all of their note-taking goes regardless of the topic, because then they don't have to worry about doing anything else. That's kind of the safest way that I would say, is to assume that when you're creating a new document, it's probably creating a new public record. It might be form over substance. The times I've seen it get people in trouble, particularly at council, is you're up there clearly writing or taking notes, and somebody files a request for public records for any and all records related to the council meeting on October 12th, 2020, and there are no responsive requests. Like when the recorder pulls it, they say there's not any, but you were on videotape actively writing, you're probably going to have some questions you have to answer. Scott, what do you
Yeah, I was going
do?
to say, I've actually had this happen on occasion where people have asked and submitted requests for counselors' notes that they've made on their agenda packet or on the notepad that they had at the meeting. And again, it goes back to a lot of what Patty said. When you're an elected official, you're on the job, whether you're up there on the diocese during a council meeting, or if you're down at your favorite coffee spot, making notes in your notepad. So you always got to be careful about what you say and what you write. There's no, I made this in my private time, not on my council time. You're a counselor now all the time. And so if you're just scribbling notes on your notebook, or if you got that text, just be careful what you say. Make sure it's something that you're comfortable with, if it's on the front page of the paper, or if the person you're commenting about is going to be able to look at it. Just think of that ahead of time before you actually do it.
Great advice. Do we have any more, Julie?
Yeah, we have a few more on social media. Can counselors ask citizens for their opinions on Facebook regarding city matters?
So I think that's probably going to depend on your city, but what do you guys do in Woodburn? Do you have a policy on that one?
Well, sure. Actually, some of my city councilors have their own social media pages, and they talk with their constituents that way. That's I think something that you can do if if somebody wants to send you a social media question, a constituent, they've got a concern, they want to ask you about a pothole or some other issue that they want you to address, that can be a way of communication. If you're communicating on the city's social media page in Woodburn, we have people who monitor that and will respond and try to answer your question that way as well. However, those can be construed to be a public. You know, your private social media page, if you're acting as your city council or on a matter of city business, actually, then you got to make sure that you're attending that correctly.
Yeah, and I want to kind of add on with what Scott said. As I said at the beginning, the law's not quite cut up with social media. So if it's your city page, I would always say you should definitely assume that's public record. If it's like Scott said, his counselors have like, I am the mayor of Woodburn and this is my Facebook page and this is where I do my mayoral business for Woodburn, you should assume that that's public.
Yeah, I'm sorry, Patty.
I'm sorry, it's okay.
No, I didn't mean to interrupt, go ahead.
But the tricky one where we see people kind of getting maybe in trouble or not in trouble depending on what court you're dealing with at the moment is the private page, right? So it's my personal page, it's where I put pictures of my kids, I put recipes, my travel photos, but every once in a while I start commenting on city business and I engage in things and it starts looking like I'm doing city business from my private. Depending on what court, some courts have ruled those are public settings, those are public records, some have ruled not. So you've got to be really careful, and I think Scott had said it early, you're always on display once you become an elected official or a counselor or mayor-elect. And so if you're going to do city business, we always recommend that you do them on official city platforms so that you don't have to necessarily worry about whether or not you're going to cross into the private versus professional role. And like in Scott's case, he's got city staff that are monitoring those and retaining them for him.
A good rule of thumb is it's not whether it's on your private page or notes in a private notebook that makes it public. It's the content of your conversation. It's the city business that makes it disclosable, not where it's located. So if you're conducting city business on a private social media page, it could be disclosable in public because it's not the private ownership of that page or your notebook. It's the content that makes it public, not where it resides.
Excellent. Julie, do you think you said we had some more?
Yeah. Should a notebook be written or can it be an electronic one?
That's a great question. I think it's up to you. So I know, for example, a few counselors who are really, everything is electronic and they've got separate files for council meetings, when they have to serve on a planning commission, when they're meeting with constituents. They're just technological people and they love it. I'm old school. I want to do everything by handwriting. Quite frankly, it sticks in my brain better if I write it. So it really works with whatever you're doing. I would say if you are one of the tech people and your city doesn't give you a computer or an iPad or something to do those businesses on and you don't have access to their drives, if you don't have external access to their drives, we heard a tip a couple days ago. We have a counselor somewhere who when they do their city business, they take their notes, they have a flash drive that the city gave them and everything gets saved on those flash drives, so they're not saving it to their personal computer. So they may be typing their notes on their individual, computer, but everything they're saved is saved to a flash drive that they can give to the city. And I thought that was actually a really nice tip if you are one of those people who is with the city who has a tight enough budget that they just can't afford to buy you tech.
Okay. Next one, can we use Google Voice as our phone number, and if a public request is asked, then we would just share that instead of our entire phone messages?
So I don't know what Google Voice is. Do you know what Google Voice is?
I'm not familiar with it, but I would go back to say that, again, it's the content of the publicness that makes it public, and your ability to produce it if requested is what you need to consider, no matter what the format of the platform is you're using.
And I would say when it comes to voicemails, remember, this is the tricky part, kind of the disconnect between what we have to retain and what we have to disclose. So you are not required to retain your voice messages. If you choose to save them and you get a public request in for that voicemail, you have to disclose the voicemail. But you're not required to save any of your voicemail messages. So if you're somebody who listens to them and deletes them, you're fine because you're not required to retain them. It's when you retain them and then that records request comes in that you might have to disclose them. So it's a little nuanced, tricky part. It's lawyers. We were making life difficult for you again.
Is that true with emails too?
No, it's not true with emails. You should assume that your emails are disclosable. And since there might be some city staff on here, as a former official who did nothing but public records requests at times, please stop emailing with your colleagues about when you want to go to lunch, because those take a long time to review. Any more questions, Julie?
I think there was a clarification. So Google Voice is a free phone number as an alternative to your personal number.
Okay.
So you could give that out, say for all your city business. Would you only have to capture what's used under that alternate number and not everything else on your phone?
Yeah, it's like what Scott said. If it's city business, you should assume you have to keep it. But even if you were doing Google Voice, again, you're not required to retain those voice messages that are left there. The only requirement to disclose them is if you have saved them. So you could get 20 voicemail messages on your Google voicemail or whatever, and if you don't keep them, that's fine for the retention process. But if you choose to keep them, then you would have to search through those when you get public records requests.
And even if it was held in a third party, so if they belong to a Google account somewhere that's managed on a Google platform on a cloud, and you had to disclose those, you may have to try to obtain them that way.
We're checking to see if there's any more questions coming in.
There's several, so let me just.
There's several. What time do we need to be done by with this session?
We have a break after this.
Okay, so we'll go a few minutes into
till
the break.
11:15.
But okay, we've got a 15-minute break built in, but we'll go a few minutes into the break because of questions. But I do want to give everybody an opportunity to stretch their legs and use the bathroom.
So I think you might have commented on this one, but if you have a conversation with a citizen about a city issue and take notes, does that fall under public records?
You should assume that it does. So I will tell you, there is an interesting case for a city that's in Metro where a counselor had asserted, and the city had assumed with her that the notes that she took privately were not being held or retained by the city itself, therefore they were not subject to the public records law. That case is being litigated. It's going up before the Oregon Court of Appeals. I would tell you that the Oregon Public Records Advocate strongly disagrees with that assertion. They're essentially asserting what Scott and I have been saying. If you're doing city business, you should assume that it is a city business and it's disclosable for public records. So the league is always going to give you the most conservative advice possible. I would say that if you're taking notes with a citizen about city business, you should assume that those records are probably going to be subject to public disclosure.
And Patty, I've got a quick tip here. If you're talking to a constituent that has a concern, you take notes. I really like it if you take those notes and put them into an email or drop them off to my office, and that way City Hall can be the owner of that, and we can be responsive to that concern. We can get information to the city councilor or to your constituent with a concern, but then City Hall has the records, and so if it becomes an issue, it's not you. People be coming to City Hall for the information. It takes you out of the equation. So it's always good to share that information. I know that if there's a constituent concern, your city manager or city administrator is going to want to know about that, and then we can be responsible for the accountability attached to it.
That's a great tip, Scott. What else do we have, Julie?
Can you speak to reasons or drawbacks as to allowing active public comment in social media forums during a public meeting, for example?
So I don't know if there's, from a legal perspective, it's just making sure that you maintain the records and making sure that you don't start, I don't find people to always be their best self on social media. I think sometimes the anonymity or the space allows us to be a little bit less than gracious and polite. So the only thing I would say with my clients when we used to do that was, you can't delete the comment that says, Counselor Movahill is fat and I don't like what she's wearing. You need to be a little bit mindful that you've created a public forum, and you need to not just necessarily only keep the comments you like and delete the comments that you don't like or that aren't supportive of your position. I don't know, do you guys have any practices that you do during council meetings, Scott?
Well, not necessarily during council meetings, but the thought that come to me, and I've seen this before, is when counselors engage in social media elsewhere. Somebody is talking, saying derogatory things maybe about you or your position or the city, and you want to mix it up. And trolls like nothing more than something to do. And if you're an elected official, you're now a public official that's engaging, and that's really rewarding to the people who want to have a fight. So I say use caution. If something is really compelling on social media, it needs to be addressed, and rarely do I ever see anything that I think really requires the city's attention. Have City Hall try to address that. I'd really try not to feed social media for the very reason that Patty said. Unless it's a very compelling matter of public interest that needs to be addressed, my house is on fire, okay, we should all call 911, but if you post that, we see it, we might respond to that. But the other stuff is this social media trolling. I'd say give that a pass.
The other thing, and this is not mine, I heard this from a couple of people as we've moved to the Zoom platform, is particularly when it comes to official meetings, you have to remember that even for Zoom, a lot of people call in because they don't have secure internet or they're on the road and they can't see those comment features. So I've actually had a couple counselors who've said that they ask the council themselves and staff not to actively engage in a lot of the comments themselves because they feel like it's exclusionary to those people who may have been calling in because they can't actively see and participate as well. So just think about that as well, that if you don't have everybody using the same type of platform and medium so that they can actually see what those comments are, you might be unintentionally excluding people from seeing the entirety of what's going on.
That's a great point.
Julie, we have any more questions?
So we actually have a question related to that regarding Zoom. If they do allow messages to council members, and if city officials respond, do cities let them respond to the public's chat content via audio or in the chat? And is it a means for only the public to voice their opinion?
I think it's going to depend on your city. I mean, that's kind of really, this is kind of one of the key things about the league is that we want every city to follow the law, but we also want each city to develop policies and procedures that work best for them. So my guess is the protocol that Scott's has in place in Woodburn might differ slightly than perhaps a policy that's in Dayton, Oregon, or Salem, or Medford, Coos Bay, Ontario. So those are the types of questions I think that you need to have as a council and figure out with your staff what's going to work best. Make sure that you're talking with your city attorney and your city manager so you're using best practices and you're complying with the law. But when you start to get into the nuts and bolts, I think that that's pretty much a city decision.
It is, and if I understand the question correctly, and I'm not sure I heard it exactly, but in the course of a meeting, if you're on social media and people are firing questions off just random, you're going to lose control of your meeting. There's a time and place on your agenda for public comment, and that's the time to take comment from the public so that it can be addressed appropriately. Maybe there's a question that the city manager can answer, maybe the public works director can respond, maybe the staff will need to get back to that particular citizen with the correct answer. If you're having free-flowing conversations individually between you and people and out in your community, while other city business is going on, it's not really serving the interests of the public or the city council. A controlled format where information can be received and dealt with in an orderly fashion that's transparent and accessible to everybody is really the best way to go.
How are we doing on time, Julie?
It is 10:54, and our break was scheduled at 11 to 11:15.
Okay, so do we have any more questions?
Yes. What is the penalty if in the process of answering a public records request, an item is inadvertently missed or discovered later?
So I don't know if I can give you the penalty off the top of my head. What I can tell you is that that's not uncommon. It's not. As somebody who used to do this on a regular basis, and I think, Scott, you mentioned it earlier, a lot of times when people don't follow rules or procedures, and even public records, it's unintentional. We don't mean to, right? So there could be some penalties, there could be some fines. What I've typically found in working with state officials in this area and with people is that we're all trying to do our best. And what you're going to find, particularly if you're newly elected officials, is public records requests can be massive. And by that I mean if you've been working on, let's say, a water rate increase for 6 months and somebody wants any and all records, including emails related to that water rate increase, you could literally be talking about thousands upon thousands of pages of documents that we have to go through. So accidents do happen. The point that I always used to try to convey to my clients is that's why it's super important to have that conversation with your city manager and your city recorder about the records you keep. How are you keeping your records? Where are those records kept? And what expectation does your city manager and your city recorder have for you with those records so we can try and prevent us accidentally missing one? If the city recorder knows that you have a notebook that you always take with you and that's where all of your notes are, then your city recorder knows that she's got to ask you for that notebook when she gets a records request related to that water rate increase. Any thoughts on that?
Well, no, I agree, and a well thought out public records request process is important too. A lot of people don't understand the volume of information we work with, even in our smallest cities in Oregon. What seems like should be a simple request for information really could be thousands or tens of thousands of documents that have to be looked at. So having enough time, explaining the process up front, I think is important, and trying to get it as right as you can also. We've had to disclose records after the fact in this format, and usually it works out. People understand. You know, if you find a record and you do a follow-up with that person, you know, usually that's okay. But being honest about really what it's going to take to get the answer and to get the documents is, I think, important. And most people don't understand just exactly how much paper we have.
Which is why I say, if it's really not related, I mean, seriously, those emails where you're talking about lunch or you go up into those sidebar personnels, if it started off work related and then you had 45 streams of communication that are offline, we have to read through all of those when we're doing your public records request disclosures. So just be mindful of that, and be gracious and do your best. But the most important part is have the conversation with your city manager like Scott or your city recorder and find out what you need to be doing so that you can make that process as smooth as possible. Do we have any more questions, Julie?
What issues arise with elected officials having open meetings intended for the public, such as having coffee with a counselor?
So we'll get to public meetings later on in the afternoon, but really quickly, generally speaking, the public meetings law is only applicable when you have a quorum of your council that's meeting. So it's fairly common. I know lots of city councilors or mayors who do, like the coffee with the mayor, or there was a former mayor in the metro region who used to have like fireside chats. He used to put a fireplace going on his iPad, and he'd go around town and he'd have fireside chats. I think that those are perfectly acceptable. It's not an issue under the public meetings law because it's just one person. I think it's a good way also to engage with your constituents, because a lot of constituents find public meetings pretty intimidating, and it's a lot easier to talk to their elected official in a coffee shop than it is to come up to a podium during a council meeting. But do you have counselors who do different things, Scott?
Well, we do, and we have over time. And as an elected official, there's nothing wrong with reaching out and communicating with your constituents. Public records are about records, and so dealing one-on-one with constituents or having those opportunities to interface with your community are, I think, good things to do. It's when you start having a few other counselors tag along, and pretty soon you have a quorum, and now you're deliberating on an issue or a community problem, and that's when you start maybe getting close to the line. If you have a quorum, then it could be potentially an illegal meeting, which I know we're going to cover later today. So talking with people is good. Having coffee with people, if that's what you want to do, and there's nothing wrong with that. Holding quorums or deliberating on business with counselors can be problematic, and I know we'll get into that later. So,
It's a good question.
yeah, it is.
Any more, Julie?
If a city does not have an email or social media policy, then do these rules only apply after they get the policy established?
No. So the public records rules, they're going to apply whether you have a policy for email and social media or not. And I think that that's okay that you don't have one, because it's still relatively new. So what I always say is, if you learned something here today, and if it's that, wow, we don't have an email policy or a social media policy, then the solution is not to panic. The solution is to go back, talk with your city manager, see if you guys want to have a conversation at a council meeting that's publicly noticed, and start talking about, okay, you know what, best practices would suggest that we have a public records retention and disclosure policy. We would have an email policy. We should have a policy about social media, and start talking about what it looks like. And in my experience, and I don't know if Scott's yours is different, the great thing about municipal government is we all work together. So if you were looking for sample policies, you could probably call somebody like Scott and say, hey, can I take a look at your email policy or your social media policy? You could call somebody in Beaverton, you could call somebody in Staten, you could call somebody in Bend, and just pull from all of your collective partners across the state and figure out what they're doing, what do you like, what do you don't like. This would work in your community or it won't. So you don't have to start from scratch, but you should start having those conversations if you don't already have them.
And I think an important point just to add on, Patty, is these are really good questions, and it's always good to ask the questions before you do it. Is this going to be problematic from a public meeting standpoint if I do this? Go talk to your city manager about that. Is this going to be problematic if I respond to this social media post on somebody else's page? Well, talk it out first. What do you want to say? What's the proper way to address this? What is the truth about the information here? It's always good to have this conversation with your city manager, to have these conversations with your peer city councilors in appropriate times in the scope of meetings. But it's always good to have these conversations ahead of time before, it's always easier, what they say, to not break the egg than try to unscramble the egg.
Good point.
Okay, we have 2 more.
Okay.
As a counselor-elect, do I need to flag any work I do now in preparation for the beginning of my term as a public record?
No, so the public records law doesn't apply to you until you officially become that elected official. But I am going to caution, because this happens every year around this time, is that the league gets inundated with complaints about counselors and mayors-elect. Are they breaking the public meetings law? Are they destroying public records? And Scott said it a couple times, and I think it's clear. You are now in a spotlight for which you weren't when you were a private citizen. So legally, you are not required to keep those records. You're not subject to public records law at all. But that doesn't mean from a perception standpoint from your citizens they understand that. So you might want to have a conversation, again, with your city manager if you're going in, or your administrator, and just kind of figure out what that perception looks like. You would be legally fine to take whatever notes you wanted to right now. You don't have to keep them because you're not subject to the law. But I do think perception can become an issue once you kind of have that spotlight pointed on you.
Okay, last question, then we'll go to a break. What is your opinion? Sorry, I lost it. What is your opinion then on allowing social media public comment to give the public better access and transparency with concerns to the agenda topic, but not engaging these concerns during the meeting and instead saving the questions to be answered after the public meeting has concluded, also preserving concerns for the record? This allows a better perspective of public concern and allows for maintaining a control of the meeting.
You want to take that one first, Scott?
Sure. Well, we answer a lot of questions on our city social media sites. You have a question or a concern or have a response to something we posted, we respond to the city-controlled content that we develop and provide to the community. And in the course of meetings, I get asked questions all the time during city council meetings, before and after the meetings as well. And we always get that information to people the best we can. So I don't think it's problematic to have questions asked during meetings or even posted on social media. I think it's how they're handled. And if it's a continued dialogue through the course of all the business on your agenda, then I think that's problematic. And if it's people asking their city questions about things they're concerned about throughout the course of the week, we do that routinely.
If I can add on, Scott, what I think the problem kind of a little bit with social media is if you take yourself out of the Zoom meeting, if you would go back to a regular council meeting where you're all in your chambers, typically what we would advise is that public comment is that. It is the public's opportunity to comment. It's not an opportunity for us to engage in a dialogue. And you see most counselors, they will say, like, we're here to listen to you. If you ask questions or you're raising issues, you know that city staff's taking notes and they're going to address it and we'll get back to you. That shouldn't change just because you're now on the virtual platform. So I think you're right. If you've got an opportunity for people to do public comment in the chat feature during agenda items or while they're working, that's great. But don't start engaging with them, because you wouldn't have done that in the real, in-person setting. Keep a note. City staff will get back with you. We're tracking them. And I think that's what you'll see. I just think that technology in some ways has made us more informal, and it's super easy to respond really quick, and we need to kind of refrain from that. It's a chance for public to comment, not for us to engage in a dialogue. That's going to derail your meeting. Scott's right. If you start doing that, you're going to lose control pretty quick.
And Patty, when we take questions from members of the public at our meetings and staff responds in a day or two, we always copy the city council in and say, councilors may recall, Patty came to the meeting, she asked us a question, we responded, here's the answer, so everybody has it. And you can see that we were able to address that question.
That's great.
When city planners are having multiple calls with developers and their legal representatives, are they required to document that call for public record?
No, the public records law does not require you to document anything. So if you're somebody who doesn't take notes and doesn't document stuff, there's no requirement under state law. Your city may have some policies. I know some cities, for example, particularly if they have like a development file, they'll have like a fly sheet. So anytime somebody touches the file, you're supposed to put a note of the contact in there. But there's nothing in the law that requires you to make a record.
Okay, the next one is, what does, quote, technically a crime, unquote, mean? It's either a crime or it isn't.
It's a crime, but there's, I mean, I think anybody who's a lawyer will tell you it is a crime, yes, technically. Do I know of anybody who's ever been severely penalized for it? No. And I say technically because I think everybody who is in public work or in public office, particularly if you're new or haven't really understood the public records law, at some point you've thrown away or shredded some notes you were taking or just pitched some Post-it notes, and that's not permissible. Do I think that you're going to get slammed with thousands of dollars in fines or thrown in jail for it? No. So when I say technically, it's meant that you are supposed to follow the law, but don't have any fear that you're going to, end up in prison for doing it, unless you're willfully destroying records, intentionally and with malice because you're trying to hide something.
Okay, next question is, so if I take notes on my computer, it's not public record?
It is. So the general rule of thumb with public records, what I always tell people to err on the side of caution, if you're taking notes related to something for city business, then you should assume it's a public record, regardless of whether it's notes that you're writing or that you're typing. What I heard a good tip a couple weeks ago from a counselor who cities does not have enough funds to supply them with, say, a laptop or a Surface. But she's somebody who prefers to do her notes electronically. So what she did have her city do was her city buys her flash drives, and so all of her notes and all of her records she always saves to a flash drive instead of her own computer hard drive, so that it's still the city is retaining that, and she can turn that flash drive into the city official, which I thought was a really unique way to go ahead and make sure that the records are still the city's records while you're using your private device.
Okay, next question is, if I have totally separate email accounts for city and personal use, but both email accounts are on a personal device, are the personal email accounts subject to disclosure?
Not in the public records, probably not either if you were in litigation. If you're keeping them completely separate, what public records law cares about is that public account where you're doing your public's business, and that's what would be disclosable.
Next question is, what if people request records by email, not via public records request?
That's probably pretty common, and the solution to that is to really have an actual records disclosure policy. Each city is required to have a policy that identifies how you're going to not only retain your records, but how you're going to disclose them. Some cities, a lot of your bigger cities, they'll actually take public records requests through the internet. So they've got like a form with a link, citizens download it, and then just send it to the city recorder. Some cities is you have to mail it in or personally deliver it. It's really going to depend on what works best for your city, what works for your city, what technology you have available to you, and then whatever that working mechanism is, that's what needs to get written into your policy, and then just continue following that policy forward whenever you get those requests. When I was doing public records, our policy always was it had to go to, we called them a city clerk, it had to go to our city clerk, not us. And I would occasionally get requests that way. Now, my city's policy essentially was if it came, say, to the lawyers were required to respond to the requester and say, we are not allowed to take records requests, you have to go through the city clerk, here's the link that you use to get there. That way there was always a track, and then what we also did as a city is our city clerk kept a log of the date, the time, and who sent the public records request, just to kind of help make sure that we were complying with those statutory deadlines.
Next question is, if a counselor wants to review documents or records, do they have to go through the public records request process?
That's typically an issue that each city decides for itself. And by that I mean, I know some cities, any records the counselors want, they're entitled to have, unless it's for some reason a confidential one. So for example, remember, you don't necessarily discipline employees, so a lot of times you won't have access to those. If your city has a police department, you can't get access to the investigatory records. But other than that, a lot of cities will just say counselors can get whatever public records they want. They just have to ask the city manager or the city recorder. Some, they ask that there's a limit in terms of staff time, like how much is it going to take. What I think is usually pretty common, kind of a solution is the council and the city manager kind of establish operating kind of agreements in terms of how council is going to utilize staff. So, if you're talking about pulling 500 records, that's probably something you need to work out with your city manager, because the city recorder's got a bunch of other stuff to do. If it's maybe, look, I just want to see the council packet from, 3.5 years ago on this particular ordinance, that's probably something that your recorder can just give you. But it's a conversation you need to have as a council, and that conversation should include your city manager or administrator to make sure that the staff resources are utilized according with all of the other responsibilities that they have.
Next question is, how do we handle a situation where documents are developed or revised on a home computer and need to be sent back to city staff or citizens? My city iPad does not have the capability to modify or develop all formats of documents.
So remember what the public record says is that if you have a copy, a true and accurate copy of it, then that can count as well. So if, let's say you went through 3 drafts, then theoretically those 3 drafts you should probably all keep. There could be some exceptions where you could get rid of them, but I always think those decisions about whether or not a document needs to be kept or can be destroyed are best left to your city recorder, city manager, and city attorney, because they're the ones who are going to really understand the nuances of the law. So if you had to make 3 separate drafts at home on your personal computer, I would just go ahead and funnel those drafts back to your city recorder so that they can be the person who's responsible for deciding whether or not they need to be retained or disclosed if they get a request.
Next question is, if I use a personal computer for public work, the work I do on the computer is a public record, correct?
Yes, generally speaking, yes. Generally, the rule of thumb that I always say is if the work that you are doing is in any way at all related to what you do for the city, you should err on the side of caution and assume that it is a public record.
Okay. Next question, when you schedule a meet and greet with a fellow counselor, would you advise not putting an agenda in the calendar invite and provide it at the beginning of the meeting, so not in writing?
So I'm never going to suggest that you don't create writing. I think that's up for you guys to decide what you're comfortable with. The only thing I ever tell people to be cautious about putting something in writing is something you wouldn't want to see on the front page of the paper or you wouldn't want to have to testify to under oath. So I have worked with people who just don't like records because they don't like having to cull through them and they don't like having to figure out whether they're using the right words or not, and they don't create any, and that's up to them and their discretion. But generally speaking, if it's an agenda and that helps you guys have an effective meeting, there's nothing that says that you can't and nothing that says that you have to. It's really up to your individual discretion. Just know that if you create that record, it probably could be subject to public records one day. So don't put something in there inappropriately, like if you call each other nicknames or you say perhaps something inappropriate joke-wise, that might be bad form.
Next question, if I scan my notes to electronic form, can I then destroy the paper copies?
If it's notes, generally speaking, yes, that's usually true if it's a true and accurate copy. There are some records, they're not going to be related to your notes that we have to keep in original format, like deeds and stuff like that. But generally speaking, if it's just your notes and you want to scan them and give them to your recorder, that should be fine.
I think this is just sort of a clarification. I thought I heard you say something about setting up a separate email account for city business. Is a separate Gmail account sufficient?
Yes, so and the only reason I suggest that is some of our smaller cities don't have the technology or the finances to invest in the technology to have an official city email account. If your city does, so like for example the city of Salem, I know they do because I sit on one of my city commissions, I would never encourage their counselors to have a separate Gmail account for city business. They should be doing their city business through their City of Salem account. However, if you happen to be in one of those cities that does not have a city-provided email account for you, then yes, it would be my recommendation that you create your own Gmail account, which would be fine, and that's where you do all your city business from. Don't mingle it with your personal, or even if you have a private business, don't mix it with that email either. Keep it completely separate.
The next 2 questions are related. Are emails and texts made before you took office part of the public record? And as a counselor-elect, is your communication with the city and other counselors before you're swearing in public record?
Possibly. If you are emailing or texting somebody who is a city official today, so if I was a counselor-elect and I was texting the mayor, that exchange is going to be a public record because the mayor is a public official if it's about city business. If you, as a counselor-elect or mayoral-elect, are texting or emailing people who are not city officials, then you're not subject to the public records law. The public records law is only applicable to public officials, and when you're in a counselor or mayoral-elect status, you are not yet a public official. You'll trigger that once you take your oath of office and presumably on January 1st when you take office.
Next question, is there any way to protect our work product or thoughts we have and take note of?
Yes, so what I want you, particularly if you're elected officials, to remember is that there are exemptions. So just because we have to retain records doesn't mean that every record has to be disclosed. And there are some instances where we don't have to disclose deliberative material. But it's not always the case that that can happen. So what I always recommend in terms of best practice for elected officials is just assume that when you're doing the city's business or you're taking notes, that those are records that are going to have to be retained, and err on the side of caution so you don't do what my department head did and say, like, this, these citizens are smoking meth, this woman's crazy, why am I here, what's wrong with this community? Don't put those in writing, because you should assume that those might be disclosable. But there are some ways for deliberative materials to be withheld from disclosure in some instances, but there's certain criteria that has to be met, and your city recorder will usually work with your city attorney or even your city manager to identify whether or not it can. But just assume that everything you create has to be retained, and make sure that you're not writing anything you wouldn't be comfortable being disclosed.
The next two questions are related to social media. What about social media? What are the rules? Can other counselors make comments, or would that violate public meeting laws? And then can you please address social media posts? I believe all posts on social media or any platform are public record.
Yes, so social media is one that we get a lot of questions on, and it's tricky because while social media has been around for what seems like forever, the law has been a little slow to catch up. There's a great resource, it's not one I put in your slides, but if you would Google like Oregon Secretary of State social media public records, there's a 3 or 4 page policy that they've put out. Generally speaking, if the social media, let's say there's 3 areas where I say that kind of break it down. So you've got your city's Facebook page, your city's Twitter account, Instagram account, LinkedIn account. I'm sure there's something people much younger than I know about as well. Those are going to all essentially be public records that you should be mindful of. And if you remember from the video, how we decide how long you have to keep a public record is really based on the content of the record, not the medium in which it's stored. And so certain comments on, say, a Facebook post or responses to a Twitter feed could have a different retention schedule per se, but it's my understanding, and technology and I don't like each other, that for the most part there's a way to either through those platforms themselves archive those, or there's third-party vendors who can help you archive, or some of the smaller cities are just taking screenshots and keeping them that way. But if it's your city's Facebook page, you should assume that that is in fact a public record. If you have your own mayoral Facebook page, so let's say you are the mayor of Central Point and you want to have a mayor of Central Point Facebook page, and everything on there is related to your duties as mayor, to what is happening in your city, you should assume that that is a public record. The tricky one, where the law is still kind of working its way through, is where it's mine. So it's Patty Mulvihill's private Facebook page. And let's say I decided I was going to run for council and I got elected. It's never going to happen, but let's pretend. So I'm now a councilor, and on my private Facebook page, I'm posting stuff about city business and people are responding. What the Secretary of State would tell you and what sub courts would say is, even though you're doing it from your private Facebook page, it's still a public document because you are really acting in your public persona, not your private persona. And so that would still be a public record. So what I typically tell people, particularly who are new in office, is the first person to talk to is your city manager, and if you don't have one, your city recorder, and find out if your city already has a social media policy. More and more cities in the last 5 or 6 years have developed social media policies, and they've developed them to not only comply with the public records law, but to also comply with free speech issues that arise under both the federal and state constitutions. So your city might already have a policy, and if it does, you're probably going to have to follow that policy. If your city does not yet have a policy, then it may be time to consider having one. And if that's the case, you would discuss that as a council with your city manager, your city recorder, probably bring in your city attorney to kind of help make sure you're complying with the public records law, the public meetings law, and quite frankly, some of the constitutional provisions, and develop that policy. There's lots of really good samples out there. You don't have to reinvent the wheel. Many Oregon cities have kind of already done a lot of the work for you, and you can kind of just grab what you like from theirs. But that's generally what I tell people to be careful of, is to see if you've got the policy already in place and then follow it. And if you don't, you want to establish a social media policy. I think social media has been super amazing for us, particularly as elected officials. It allows us to communicate with a certain segment of our society that doesn't want to show up at council meetings themselves. But we've got to be mindful that it does still create some pitfalls that we have to figure out ways to jump over and make sure that we're still complying with the various laws that come into play with them.
Okay, we've got about 9 minutes left in the Q&A and a couple more questions to go. The next one is, what about separation of city email accounts from election campaign accounts in social media? Is there a line between issues discussed during an election campaign and the council's positions and discussions?
Maybe. Oh, don't you love these lawyer answers? Sorry. Okay, so if you're not currently in office, okay, so you're not a sitting councilor who was running for re-election. You were just brand new. When you were in campaign mode, at least under the public records law. Now, I don't do anything with campaign laws whatsoever, so I'm not the person to ask about election law, so please do not rely on me or think that I'm your go-to person. But in terms of the public records law, remember, you're not a public official when you're campaigning if you're not currently holding office. There have been some interesting issues where you've got sitting councilors. So Patty Movahill is already a councilor and she's running for re-election. There's been some interesting issues about how that campaign page may interact with public records if I start doing city business on it or talking about city policies. And so if that's the situation you find yourself in, those are one of those instances where it's really, really helpful to have conversations with your city attorney, if possible, to figure out where those lines might be with public records. Not only because you want to protect yourself, but you also want to protect your city, right? Because you're still a representative of that city today, and you want to make sure you're not violating any internal policies or any of the external laws that your city is required to follow. It's a great question, but it could be a little different depending on whether you're currently in office or you've never held office and are just seeking office today.
Okay, next question. This Monday, the councilors-elect in my city are required by law to participate in a city work session. If I take notes during the meeting, even though I have not been sworn in, are those notes a public record that have to be retained?
No,
She said I should clarify, that it's by city ordinance.
okay. So under state law, which is all I can really speak to, if you are still a councilor-elect, under state public record law, you're not part of the public entity yet, so your notes are your own. If you have a city policy, talk with your city administrator about whether or not that policy somehow applies to councilor-elects as well. That's the law. What I do want to tell you also is perception is going to start to matter to you in a way that you cannot expect if you are a newly elected official. And so there is what the law requires, and then at times there is what your citizens may expect. And the reality is, in my experience, once you become a councilor or mayoral elect, your citizens have a different expectation of you than they did even when you were running for office. And so sitting in those meetings, taking copious notes, it does not subject you to the public records law, but if you've got citizens in there, they may expect to want to see those records. It doesn't mean they get them, but their expectations of you are literally changed as soon as the election was over and you were declared the winner. So it's also appropriate, I think, sometimes to ask yourself and ask more senior members on your council who've been doing this, what does the community really expect from us? Are they trying to hold us to a different standard? Because remember, the public records law is the floor, it's not the ceiling. So your city can require more, and your citizens might expect more. So always kind of keep that perception issue in mind, because sometimes perception can hurt us a little bit more than not complying with the law, to be perfectly honest.
Next question. Would the social media policy go into the council rules or in a council handbook?
That is going to depend, quite frankly, on your council. So I've seen some put it in their rules of procedure. I've seen some cities and counties who it is a separate standalone policy. So it's just almost like a personnel manual, for lack of a comparison, is that it is a separate standalone policy. They've got sections that apply specifically to elected officials. They've got sections that apply to staff, but it's a standalone document or policy. It's going to depend on what works best for your individual community.
Another social media question. Are Facebook posts made concerning city council decisions before you take office a part of the public record or an ex parte contact?
So again, if it's your Facebook page that you made on your own private account before you took office, then it wouldn't be part per se of the public record because you're not a public official yet. If you made those comments on the city's Facebook page, then it's going to be part of the public record because the city is a public entity itself subject to that. In terms of whether or not it's an ex parte communication, that's going to depend. So, and by that I mean, if you are, once you're elected and sworn in, so let's say in March, you're asked to make a decision about a land development issue, and 5 months prior you were all over Facebook private pages making comments, getting information about that, you probably got information about that land use decision outside of the hearing in which you were making a decision. So you want to talk with your city manager, your planner, your city attorney if you have one, about whether or not those conversations are going to be considered ex parte, and you have to disclose them. And then I know I just said it in the last question, but I want to reiterate it. Perceptions will matter to your citizens. So even though those Facebook posts on your private account before you take office are not subject to public records, I guarantee some of your citizens have seen them, and they may have a perception that they should be allowed to continue seeing them or should have access to them because you're in a new status now, whether or not you are under the public records law.
Okay, we've got about 3 minutes left and 3 questions, so let's go ahead and, are records of executive session deliberations public or discoverable?
So they're not generally public. They could be discoverable. So when you say discoverable, to me that's a legal term, meaning we're in some type of litigation or administrative law hearing, and somebody has filed either a discovery request or subpoena for those records. In some instances they could be. It just depends. That's going to be an issue for lawyers to fight out. But generally speaking, they're not subject to public disclosure.
If a current counselor is talking to a counselor-elect, is the current counselor's text part of the public record, or could be?
If they're talking about city business, yes. I would err on the side of caution and assume so.
Okay, and our last question for this Q&A, are video streaming on platforms like Zoom for public meetings, are we, hold on, it's popping in here. Are we supposed to record them for public record? We are going to begin meeting over Zoom.
So the way the public records word works is you're not required to record anything, so but you can do minutes. I would say that most cities, in my experience, who are using Zoom are recording them the same way they would do an audio recording if you were meeting in person. And that's really because when it comes time to type those minutes up, it's a lot easier for the recorder, who's usually the person typing them up, if they have something to refer back to, so they can double check who actually made the motion, who did the second, how was the motion specifically worded. So it's my experience and understanding that most cities that are holding their meetings via Zoom are doing so and recording them.
Okay, 2 more questions just popped in. We're at 10:58. You want to go ahead and tackle the last 2?
Let's tackle these last 2. If there's more after that, please know that Denise will send me those emails electronically, and then in the next 2 to 3 working days, because it's Friday, I will provide everybody who registered for this class an email that has the questions and the answers in written format.
If a counselor receives text regarding city business either from city officials or constituents but does not text anything back, is that phone subject to public disclosure, or would that be the responsibility of the generator?
So if the city's officials are sending it to you and you don't respond back, particularly if they have city phones, I would assume that they have it and you don't have to worry about it. Even though you don't respond to a citizen, it doesn't mean that it's not a public record. So a lot of times we try and make distinctions between text and emails, but it's really not. So like if you got a letter from a citizen and you didn't respond back, but you kept it, that could probably be a public record. So I always tell people to err on the side of caution. It's always better to be safe than it is to be sorry.
And the last question was relating, similar topic regarding social media.
Okay.
Just as far as if you don't answer them, is it still public record?
Yes, and so that there is some suggestions of that. So again, just remember, if you really quickly have time, I'm sorry I didn't include it, but if you Google Oregon Secretary of State Public Record Social Media, they're going to give you some really specific guidance on what to do with social media platforms, be they Facebook or Twitter, and help you in terms of what you should or should not consider a public record that you have to keep. These are all exceptionally great questions. Public records is super hard to understand and get a grasp of. Before I let you go for your break, my biggest #1 tip for all of you when it comes to public records is to sit down and have a conversation with your city recorder. They really are, in my experience, almost issue area experts on public records. They're going to be able to tell you what your city requires, what your city expects, and help you work through where your records are stored, what you have to disclose, and help you develop a management system that works for you in line with the city's policy. Your city recorder will be your best friend when it comes to public records, and that's why I recommend you have a conversation with them sooner rather than later. Okay, so in case any of you are furiously typing and trying to put it in, I just want to reiterate a few things that we talked about in the session. My 2 biggest takeaways for any newly elected counselor when it comes to public records is to really sit down and have a conversation with your city manager or your city recorder as soon as possible, and figure out how your city maintains its public records and what their policies are for retention. The sooner you can have a conversation and understand your expectations for the records that you can create, and the sooner you can come to an understanding about how those records are managed and kept, the better it's going to be in the long run. Like most things in life, if you start thinking about this in June, you already have 6 months of documents and emails and text messages that you have created that now you have to go back and figure out what to do with. If you can have those conversations early on in your career as a counselor or a new city employee, it's going to be a lot easier to manage. The second thing I always want to say is when we do an analysis of the type of inquiries we get at the league, public records is usually at the top. It's usually the first or second #1 type of inquiry we receive. So again, if you've got an issue with public records and you don't know where to start, please feel free to call the league. Jamie Colton and I are well versed in public records law, and we're happy to answer those questions. And if you just want a cheat sheet, there is that link on the last page for the Attorney General's Manual on Public Records. It's a lengthy document, I'm not going to lie, but it is really easy to read, and we at the league use it as a desk reference fairly regularly. So it's a good tool to keep in your proverbial toolbox. Those would be kind of the biggest takeaways I'd want you to take from today's session on public records. Any questions, Julie?
Yes, we have a few in the chat.
Okay.
What about notes from city trainings such as this? Would that be considered a public record?
Possibly. So if the notes that you're taking is about city business, generally speaking, you should assume that it's a public record. My only caveat for those of you here today, you are not subject to the public records law until you are sworn in as an elected official. So if you are a counselor-elect or a mayor-elect, anything you do between now and when you get sworn in is not technically a public record because you're not yet a public official. That said, remember in the last Q&A I talked about how perceptions matter. Your constituents may assume that they are in fact public records, so you may want to make sure that you're prepared to answer and explain why you're not turning over something. But I would generally say notes, I assume that they are public records if it's related to your city business. But if you're newly elected here today and haven't taken office yet, those would not constitute a public record because you're not yet officially a public official.
Next question. My campaign social media pages are now identified as counselor pages, controlled by me, not city staff. What is your recommended policy about moderating comments on my social media and retention of those comments?
That's a good question. We get a lot about social media today. So what I typically tell people is even if it's your own page the city's not controlling, if you're doing city business on that page, you should assume that it is a public record. What's interesting about public records law is it doesn't tell you how long to keep a document based on the format. It's really based on the content. And by that, it's not you have to keep emails for 30 days or you have to keep Facebook postings for 20 days. It's really whatever the posting is about. So the subject matter, was it related to the budget? Was it related to an ordinance? Was it related to a resolution? Was it related to sewer hikes, increases, stuff like that? It's about the content. What is really useful, and I'm sorry I did not include it in the slide, but there's two things to do. The first is if you just Google Secretary of State, Oregon Secretary of State Public Records Social Media, they actually have a handy dandy flyer that will come right up, and it will give you some advice on retention protocols. So I would look at that. But you should assume that your own social media page that you have as a counselor is in fact a public record. The second thing I would encourage you to do is a lot of cities right now are creating social media policies. And so you're going to want to talk with your city manager or administrator and see if those policies exist and if they do, if they have any implications for that newly created page. It's becoming more and more common for councils to adopt comprehensive social media policies that apply not just to the official city Facebook page or Instagram page, but also apply to those types of individual pages you're talking about. And so you're going to want to see if A, there's a policy that exists to see if you've got any issues you need to address. And if your city hasn't adopted a social media policy and you want to have a conversation about the pros and cons of doing so, that's also a good thing to do. And the reality is you wouldn't have to start from scratch if you wanted to. There are many cities, counties, and even special districts who have kind of already done building the social media policies. The league's got some of them on file. We could share them with you, and then you could kind of take what you like and build from there. But generally speaking, you want to assume that if it's city business on that page, that it's probably a public record.
The next question I believe you already touched on, but are records I create as mayor-elect subject to retention as public records?
Not under the public records law. So it only applies to public officials. Theoretically, your city could have a policy, but it would strike me as odd if they did. So generally speaking, those records you create aren't. The only thing to be mindful of as a mayor-elect or a councilor-elect, if you're communicating with somebody who's already in office, so let's say you're mayor-elect and you're discussing something with the council president is subject to public records, so those communications are still going to have to be archived by the city or the council president, because they are a public official. And that would also apply for staff. So if you're a mayor-elect and you're emailing your city administrator, the city administrator is a public official subject to public records law, so that communication is probably still a public record, even though the onus is not on you because you're in a mayor-elect status.
Some elected officials have events like Coffee with the Mayor. Now some of these events are held virtually. Do records need to be kept?
So it depends, not necessarily. So remember, like the spoken word is still not inherently required to be kept. So let's say you're just doing a Zoom meeting with constituents and you have the chat feature disabled, so there's no record of that. You're just talking to them virtually and you're not recording it. That's not a public record or a public meeting you had to keep, so you don't have to worry about it. Now, if you did enable those chat features, or you're doing a Facebook Live event and people are able to comment, then you probably are creating records per se. But if it's just calling somebody on Zoom and you're just having a face-to-face meeting or Skype or Microsoft Teams and you're not enabling chat features, there would be no requirement that I'm aware of that would require you to record those any more than you would have to require the coffee with a counselor at your local coffee house.
Are there grants available that can help provide city councilors devices, such as laptops, to help manage and keep these documents separate from personal computers and phones? Or is it a notebook the best recommended method of record keeping to avoid having any personal devices taken into question?
So that's a good question. So in terms of grant management, there are grants. I'm not familiar with any off the top of my head, so I probably can't assist you with that. What I've seen in terms of the technology of late, and this actually was a tip that came from a prior elected essentials, is one of the cities, the counselor really liked to take notes on her laptop, but her city didn't have money to buy her a laptop. So what the city does instead is they pay for her to have a flash drive. And so all of the work she does for city business, she saves on that flash drive. And then the flash drive goes to the city when it's full, because then they can keep it as a city record. And that was kind of the nuance she made there, in a sense that she built a fire safety wall by using a flash drive on her personal device instead of saving it to her hard drive, which I thought was a good solution. The low-tech one is the notebooks, if that's what you want to do. I am still myself a very low-tech person. In order for me to learn something, I actually have to touch it and be able to kind of circle around it and write it, so I still use notebooks. But if your city doesn't have the funds and you are just somebody who wants to use the computer, I would think about going with the flash drive route. It seemed like a pretty simple solution to kind of build that necessary wall in a pretty cheap way.
What about text messages?
Text messages are considered public records if they are from a public official or to a public official and they are about city business. So it doesn't really matter the medium. So whether it's you've written something, you've typed something, you've texted something, you've emailed something, you've posted something on social media. If it relates to the work or the business that you're doing on behalf of the city, then you should assume that it is a public record.
What about staff texting as a follow-up?
Staff texting would still be the same. So I'm a staff employee, as is Jamie. If we were texting each other about, say, something that occurred during today's Elected Essentials programming, both of us would assume that that text message exchange was in fact a public record because it's related to what we do as government employees.
Okay, next question. 5 business days. When does the clock start? That is, does the clock start the day the request arrives? The public records advocate tells me yes, but the city manager is saying she starts counting the next day. How does LOC rule?
It's in the statute.
Yeah, so if the public records advocate is telling you it arrives on, say, on the day it's received, then I would absolutely go with what the public records advocate states. So let's say you receive it on a Monday. That's your first day. So then by Tuesday, that's 1 day up. By Wednesday, it's 3 days, or 2 days. Thursday's 3 days. Monday, Tuesday, Wednesday, Thursday, Friday. So I think I would err on the side of the public records advocate. If there's ever a discrepancy, though, that you think is a pretty valid one between your city manager and another person, it'd be a good time probably to reach out to your city attorney in that case. Even what Patty and I think, how we interpret that, actually doesn't really impact if something was disputed in front of the court. You'd want to talk to your city attorney about that. But I think you're pretty safe to go with what the public records advocate is saying.
Yeah, and we can also double check. Another good place is, I'm pretty sure the AG's manual talks about how you calculate those days as well.
Yeah.
So the Oregon Attorney General's manual on public records has an entire section on what those deadlines look like and how you start counting as well. But Jamie's right, I would defer to the public advocate.
Okay, next question. If a particular issue becomes litigated in the courts, are there limitations to damages because of non-disclosure or violations of public records?
So there are, for damages, yes. So generally speaking, in any litigation, it's really not the damages there's certain types of damages. So what we always worry about, really, the most expensive thing typically is going to be, quite frankly, attorney's fees. That's where you're really going to get hit because there is no cap on attorney's fees. It's just what's deemed reasonable. I don't know what you pay your attorneys, but it's not uncommon to see attorney rates range on the low end from $175 an hour upwards to $800, $900 an hour. So attorney fees is where you really have to worry about it. The fines are going to be capped. And you can have punitive damages, which usually aren't capped either. But generally speaking, it's the fine is set, but the thing that you really want to worry about is attorney's fees. That's where you're really going to find the expense as a city official, is your attorney's fees.
Okay, Rachel King, I see your hand is raised. If you want to unmute your line, you can go ahead and ask your question.
Thank you. So I am a note taker, and I have in my notebook here, I've written 4 pages, and it's mostly nothing that would be easily read, just jotting stuff down. Is that something that you would routinely turn over, or do you just hold onto it for your personal until there's a public records request?
I think that's, it's really going to be, what I would tell you is, one, I take notes the same way. My guess is if I turned over my notebook to anybody, they can't read any of it, and it's not going to make any sense. But what I would always tell my counselors or any person who asks me is, have that conversation with your city recorder. Because a lot of cities have different policies. So for example, I know of one city that was on the coast and they had a counselor just like you who wanted to keep the notes themselves because they kind of kept it as a refresher, but the city recorder knew that they were there. So whenever they got a public records request, the recorder could call the counselor and say, look, we've got a records request for this. I need to see your notebook so that we can cull through them and respond. I know other cities who have said, realistically, once you finish with a notebook, we want you to turn it into us so that we can keep it. But have the conversation with the recorder so that they know A, that you actually have those records, and then B, you can figure out how you're going to go about storing them.
Yeah. It doesn't really matter what you and your city recorder decide to do, just to have that line of communication. You might think, who's going to want to look at these records from when I attended Elected Essentials? No one outside of myself really cares what my notes say. You never know, and you can't assume that someone might not someday say, I want to know what you were doing for training, how you prepared to be a counselor, and so I want to see the notes and all trainings you took prior to your swearing in. So it could happen, and as long as your city recorder knows, yep, I know, counselor, you have this notebook out there, you can keep it at home, but I know if I ever need to look at them for some reason, I know where to go.
And the only other tip I would say is when you're done being in office, so if the deal is that you just keep them at home, when you're done being in office, then I would go back and have a conversation with your recorder about what to do with them. Because if you assume that all of those notebooks that you've made over your tenure are in fact public records, once you're no longer in office, you should give those records to the city so that they can retain them themselves, instead of essentially a city record not being in the city's possession anymore.
Thank you.
Mm-hmm.
Next question is, what about communications between counselors and mayors outside of council meetings?
So those are tricky. We're going to get really into this when we do the public meeting session later this afternoon. Generally speaking, a quick kind of highlight is that you can have conversations with members of your governing body as long as it doesn't equal a quorum. Once you hit the quorum, then you need to be having those discussions in a public forum.
The tricky part, though, when you have those kind of offline conversations is you have to worry about a concept which we call a serial meeting. And what that essentially says is that you have a series of meetings with individual counselors, and those series of separate meetings equal a quorum. So the example I always like to say is if you've got a 7-member council, your quorum is going to be 4. So Counselor A and B are talking about an ordinance to regulate dogs on Monday in person. And then on Wednesday, Counselor A and Counselor C are emailing each other and they start talking about the same ordinance about dogs. And then on Friday, Counselor B calls Counselor D on the telephone to talk about something and they end up talking about the dog ordinance. Those separate conversations happening in different mediums are a series of meetings that resulted in a quorum of the council all talking about city business. And those conversations weren't publicly noticed. And that's where you run into a potential public meetings violation. So under the law, as long as you don't have a quorum, as long as a quorum of you are not discussing, you can have those offline conversations. But you need to be incredibly careful because this ABCD situation I just described seldom happens on purpose. It's usually inadvertent and unintentional. But unintentional mistakes can still be violations of the public meetings law.
And just to be clear too, if you are having, say you text the mayor, hey, let's grab coffee after, or text him outside of a council meeting, it's about the content. So if you're texting him or emailing them about city business, hey mayor, great job at that meeting, I have some follow-up questions, can we meet for coffee? It might not run into the public meetings issue that Patty's talking about, but those conversations are still public records. So you have to look twofold. You have to look, is this a public record because I'm discussing city business? Yes. Is this going to be a public meeting? That's a separate question. And you have to ask both of those to ensure you're complying with the law in different areas.
It's a good point, Jamie.
Okay, next question. If my city is incredibly lacking with setting up official email, what can be done, including posting private email address on city website?
So I think there's a lot of smaller cities that don't have the resources to have essentially city email accounts yet. And so what Jamie and I always tell people, if that's the case for your city, then I would create a separate Gmail account would be a good example. I always use the example of just create your own Gmail account that is only for city business. So let's say I decided to get really brave one day and run for mayor and I was elected. Citizens didn't know what they were doing and they put me in office. I would probably set up and it would say Mayor Patty Movahill at gmail.com. And that would be the email that I would have my city post on the website. If my city gave me business cards, that would be what would be on there. And all of my city work would be done on there. And I would keep it completely separate from my private account because then I would know that that's actually that's the public record account, essentially. That's my public facing account that I would use. That's typically what we tell cities. You're seeing more and more cities, most cities probably do have city email accounts, but it's still not uncommon in our smaller cities for the cities just to not have the financial resources to make it happen. And so if that's the case, then kind of create your own private account and that be the account that you use for your public business.
Okay. What is the timeline for a serial meeting? 1 week?
I wish I could tell you. I can't. The problem with Oregon's serial meeting law is that it was essentially an interpretation by the courts that created it. So there's not a statute. I will tell you that I have been working with, LOC also has a lobbying division. I've been working with the lobbyist who handles the public records portfolio, and they're trying to work out a compromise to maybe drop a bill where we would have some guidance. I actually originally started practicing in Indiana, and our serial meeting rule in Indiana is a statute, and in Indiana there is a time frame. It's the conversation happens within 10 days of the original, so there's a time frame. That doesn't happen in Oregon because it's an interpretation, so it's an unanswered question. Is it 10 days or is it 10 months? We don't know the answer to that, so we take a really conservative approach here at the league and just say that because we don't know what that time frame is, you should assume it's indefinite if you want to be the safest course, if you want to take the safest course possible. I am not seeing any other questions.
Okay,
So before I wrap up with this, one just last push for those of you that are newly elected officials, or for those of you that have been elected officials but haven't yet done this. If I ask you to take anything away from the public records session, it is to go back and have a conversation with your city recorder to make sure you understand what your city's records policies are and how you are supposed to play a role in that policy. So if you are somebody who's taking notes, does your city recorder know about it, and do they know where you're keeping it? If your city doesn't have a records policy, maybe sit down and have a conversation as a council about creating a records policy. But the number one thing to take from this is that there are records requirements that you as elected officials or city employees you have to follow, and usually it's your recorder who's responsible for managing those. So make sure you have a conversation with your recorder about what that policy looks like so that you're all on the same page, and quite frankly, so that you make your city recorder's job a little bit easier. Anything else you want to add, Jamie?
Nope.
Okay, so I think we go into ethics next, right?
So we're on a break until 11:15, and then ethics will start then.
Okay, so enjoy your break, stretch your legs, grab some coffee or tea, and Jamie and I will see you after the ethics session for some more Q&A.